Hello and welcome to today's video. My name is Lena Nguyen and I'm a divorce lawyer. In this video, we'll be discussing an incredibly important topic that affects many people: divorce for immigrants in Texas. If you or someone you know is going through a divorce and happens to be a non-citizen, it's essential to understand how the process may differ, especially when it comes to your immigration status. Divorce can be an overwhelming and emotionally challenging process for anyone, but for immigrants in the United States, it can come with additional complexities. The decisions made during a divorce can have serious implications on your future in this country, especially when it comes to your immigration status. Now, before we get into the details, let me remind you that the information shared in this video is for educational purposes only and is not intended as legal advice. Each case is unique, so if you need legal assistance, I strongly recommend consulting with an experienced attorney who specializes in both family law and immigration law. With that said, let's dive into the topic at hand. We'll break it down into three main areas. Number one, specific considerations for non-citizens in divorce. Number two, how divorce can affect immigration status. And number three, working with attorneys who understand both family and immigration law. Let's start off with number one, specific considerations for non-citizens in divorce. As a non-citizen in Texas, there are several important factors to consider when going through a divorce. The legal processes may be similar to those that U.S. citizens experience, but there are some key differences, particularly concerning residency status, employment, and legal rights. Legal resident status. One of the first things you should be aware of is your current immigration status. If you're living in the United States on a visa or green card, a divorce could have significant effects on your legal resident status. Permanent residents or green card holders. If you are a permanent resident, meaning you have a green card, the dissolution of your marriage may impact your ability to remain in the United States. This is especially true if your permanent residency was obtained through marriage. A divorce could lead to complications with your green card status and future citizenship application. However, this doesn't mean you will automatically lose your green card. It just means you may need to take extra steps to ensure you can remain in the United States. In fact, many permanent residents in this situation may need to apply for a waiver to remove conditions from their green card or show that their marriage was legitimate, especially if they obtain conditional permanent residency. Visa holders, non-immigrant status. If you are in the U.S. on a temporary visa, such as a work or student visa, divorce can impact your visa status, especially if your visa is tied to your spouse's status. For example, if your visa was sponsored by your spouse's employer, a divorce could cause you to lose your visa status, and you may be required to leave the country or adjust your status. It's important to know that in these situations, you may be able to apply for a change of status, but that can be a lengthy process. Undocumented immigrants. If you are an undocumented immigrant, the situation becomes even more complex. While divorce itself doesn't affect your immigration status directly, the process of divorce may raise awareness of your undocumented status if not handled properly. For example, if your spouse is a U.S. citizen or lawful permanent resident, they may be able to sponsor you for a green card after divorce, but this depends on the specific circumstances. It's important to consult with an immigration attorney to understand your rights and potential risks. Sometimes undocumented immigrants facing divorce may be able to apply for special protections like VAWA, which is the Violence Against Women Act, relief, if there are claims of abuse. Child custody and immigration status. When children are involved in the divorce, the impact of immigration status becomes even more significant. Texas family law is focused on the best interests of the child, and custody decisions may influence your future in the country. If you are the primary custodian of your children, your immigration status may affect your ability to retain custody or even to stay in the United States after divorce. While family law courts prioritize the child's best interests, a parent's immigration status may become a factor in determining custody if there are concerns about your ability to provide for the child's well-being. Additionally, if your children are United States citizens, there may be specific legal protections available for you, even if your immigration status is not in good standing. For example, if you are the custodial parent of U.S. citizen children, family courts are generally reluctant to remove children from their parents' custody just based on immigration status. Spousal support and financial considerations. Divorce can also have financial consequences for immigrants, in particular when it comes to spousal support. A non-citizen spouse may be entitled to spousal support, but there could be limitations, especially if your residency status is not stable. In some cases, a court might consider your ability to support yourself and your current legal status when making spousal support determinations. Spousal support and work authorization. If your work authorization is tied to your marriage, a divorce could impact your ability to legally work in the United States. For example, if you are on a spousal visa that doesn't grant independent work authorization, you may need to take steps to obtain work authorization after divorce. It's important to discuss your employment options with an attorney who can help navigate these challenges. How divorce can affect immigration status. Now let's talk about how divorce can directly affect your immigration status. As I mentioned earlier, if your green card, visa, or other immigration status is tied to your marriage, divorce could jeopardize your ability to remain in the United States. Divorce and conditional green cards. For immigrants who obtained a green card based on marriage, there is an additional layer of complexity: conditional green cards. When you marry a United States citizen or permanent resident, you may be granted a conditional green card if your marriage is less than 2 years old at the time of approval. Conditional permanent residence. If your marriage ends in divorce before the conditions are lifted, it can complicate your ability to get permanent residency. In this case, you must demonstrate to U.S. Citizenship and Immigration Services, also known as USCIS, that the marriage was not fraudulent and that the divorce was not an attempt to evade immigration laws. The good news is that even in the case of divorce, you can apply for a waiver of the conditions on your green card if you can prove that your marriage was real and not entered into for immigration purposes. Divorce during the conditional status period. If you divorce while in a conditional status, you may be able to request a waiver to remove the conditions on your green card. You must prove that the marriage was entered in good faith and not solely for immigration purposes. Divorce alone will not disqualify you, but you'll need to prove your eligibility for the waiver, which can involve providing documentation such as joint financial records, photographs, and affidavits from friends and family. Impact on naturalization and citizenship. Divorce can also impact your ability to become a U.S. citizen. If your marriage to a U.S. citizen was the basis for your green card and you were planning to apply for citizenship, divorce could complicate that process. The general requirement for naturalization is that you must be a permanent resident for at least 5 years or 3 years if you are married to a U.S. citizen. If you divorce before meeting this requirement, you may have to wait longer before you're eligible to apply for citizenship. Naturalization requirements after divorce. If you were planning to apply for citizenship based on a marriage to a U.S. citizen, and you divorced before the 3 years of marriage required for naturalization, you may still be eligible to apply for citizenship based on the 5-year permanent residency requirement. However, the process may be lengthier and you will need to provide evidence that you have maintained your permanent resident status. Deportation risk. While divorce alone doesn't lead to deportation, it can place you at greater risk if your immigration status is tied to your spouse. For instance, if you are in the country on a spouse visa and divorce, you could be asked to leave unless you have another legal status or your status is changed. Deportation protection in cases of abuse. If your spouse was abusive, you may be eligible for relief under VAWA, which allows you to apply for a green card without your spouse's involvement in the process. This is particularly important for those facing emotional or physical abuse, as it can provide a pathway to remain in the United States independently of the marriage. Working with attorneys who understand both family and immigration law. One of the most crucial steps when dealing with divorce as an immigrant is finding an attorney who is knowledgeable not only in family law, but also in immigration law. Divorce can have lasting effects on your immigration status, and it's essential to have legal counsel who understands both areas. Why you need an attorney specializing in both fields. Family law and immigration law are separate areas of law, but they often intersect, especially when divorce is involved. If your attorney only specializes in one area, they may not be equipped to advise you properly on the full scope of your legal rights and obligations. A lawyer who understands both family law and immigration law can provide comprehensive advice and guide you through the complexities of your divorce process while protecting your immigration status. What to look for in a lawyer. When looking for a lawyer, consider the following: experience in both family and immigration law. Ensure that your attorney has experience handling cases that involve both areas. They should be familiar with how divorce can impact immigration status and how to navigate potential risks. Consultations and fees. Some attorneys offer free consultations, which can be a great way to get an assessment of your case. Make sure to discuss fees up front and how they will bill you for services related to both family law and immigration issues. Ask your friends and family for referrals. Personal referrals can also be very helpful, especially if you know someone who has faced a similar situation. To wrap up, if you are an immigrant facing divorce in Texas, there are several important considerations to keep in mind regarding your immigration status, your legal rights, and the overall process. Divorce can have a significant impact on your immigration status, and it's crucial to work with an experienced attorney who understands both family law and immigration law to help navigate these complex issues. If you found this video helpful, please like, share, and subscribe for more legal insights and updates. And as always, leave any questions you may have in the comments below, and I'd be happy to help. Thanks for watching, and good luck.